All right, good morning, everyone. Welcome, welcome. We're gonna go ahead and get started. We apologize, we know we're starting a few minutes late, but we are so excited to see all of you here in the room and streaming online for today's Office of Government Relations Breakfast on Benefits program, where we'll be discussing the public charge. So my name is Kate Audette, and I'm the Director of State Government Relations here at Boston Children's, and I am thrilled to be joined by our friends from the Massachusetts Law Reform Institute, or MLRI. I will let our legal experts, Iris and Vicky, introduce themselves to you momentarily. But just a few housekeeping notes. We do have food in the back, so please feel free to get up if you're in the room and help yourself at any time. You did receive an evaluation form when you came into the room, as well as a note card. We'll be using those note cards to collect your questions at the end of the program. So we are going to do Q&A at the end. So if you have questions, we'll have volunteers walking around the room with blue baskets where you can place the note card. We'll consolidate questions and try to answer as many of those as we can. For those of you that are joining us on the live stream, you'll be able to utilize the chat box for your questions. And if you encounter any tech issues or anything along the way today, please utilize that chat box so that we can triage those for you. So without further ado, I'm going to turn it over to Iris and Vicky, who will first introduce themselves and MLRI.
Thank you, Kate, and everybody. My name is Vicky Poulos. I've done some of these Breakfast on Benefits before, not in these quarters, however. I do health law at Mass Law Reform Institute, which is a poverty law and policy center celebrating its 50th anniversary. And my area of focus has been immigrant eligibility for mass health and other public programs. And with me is my colleague,
the immigration attorney at Mass Law Reform.
And we're going to start with a short video, which was produced by folks in California by an organization called the Children's Partnership. It's just 3 minutes. It gives a pretty good overview of public charge. It's based in California. So when they say Medi-Cal, think Mass Health. And when they say, I think it's called Covered California, think the Health Insurance Connector Authority or Connector Care. But otherwise, what they say is really very apropos to the situation here.
The federal government is trying to change the rules, and in doing so, punish families for taking care of their children. Federal immigration officials use the term public charge to refer to people who primarily rely on the government to support the costs of their day-to-day living. Today, that only includes programs like cash assistance, such as temporary assistance for needy families, or assistance for long-term nursing home care. So far, nothing has changed for immigrants in the U.S., but there are proposed changes that would add various services, everything from health to nutrition to housing to energy assistance programs to the list of factors that can be considered when deeming someone a public charge. But using benefits is never the only factor in deciding who might be a public charge. Immigration has to consider all of the factors that determine whether a person can support themselves and their family. It also does not apply to certain groups of immigrants.
the changes go through, programs like food stamps or SNAP, the Supplemental Nutrition Assistance Program, CalFresh here in California, would count against families like mine.
My child is enrolled in Medi-Cal, so it helps us take her to the doctor to get her checkups and keep her healthy. If the changes to the public charge go through, healthcare programs like Medicaid or CHIP or tax credits that help us get insurance through marketplaces like Covered California would be affected.
However, although there may be changes in the future, your health, your well-being, and that of your children, it's important.
How does it impact me?
For now, you should continue to participate in programs like Medi-Cal or WIC, energy assistance, or housing, programs you need to take care of your family.
Immigrant families are like all families, working to protect our children and keep our families together. Some of the country's biggest advocacy organizations are taking action to oppose this proposal. Speak up. This is wrong for families, and it's wrong for America.
Share your story.
Let's not punish immigrant families for taking care of their children. Visit nilc.org, NILC.org, and make your voice heard. Let's rise up as one, for my family, for your family, for all families.
We're just waiting to get the PowerPoint on there. We're going to review a couple of those concepts and talk more about Massachusetts.
Great. So we're going to go to this first screen. We're going to sort of drill down a little bit about what this public charge change really means. How does it come up in immigrants, immigration situations, and then talk about the impact. So as you heard, the rule is that about what a public charge means is a person who is likely in the future to become dependent on the government for support. But how does this test even come about? So to take you back a little bit, since the beginning of this country's history, we've had immigration laws that decided qualitatively who would be allowed to come into the U.S. or not. We call them admission laws, laws that decide whether a person would be admitted to the United States lawfully. Over time, that list has grown, but it's, since the 1800s, always had some kind of a public charge rule on the books. One thing that has evolved, however, is that when this public charge admission rule is applied, has expanded, so that now it isn't just people who are in a home country trying to be admitted to the US, or people standing at the border trying to come in through a port of entry, but people who have been living in the United States lawfully or unlawfully for many years, who have to prove that they are admissible as if they were standing at the border for the first time. So that is why these changes in the public charge admission rule have extreme impact over a broad swath of the immigrant community. So a person this public charge test, if it applies to an immigrant, is performed both when they are overseas trying to get in, when they are at the border with whatever permission they were given at the consular post abroad, and then if they come in some status like a tourist, for example, and later qualify for some other status where admission applies, then it's applied by USCIS government officials when they decide if the person is going to be granted that immigration status. So the majority of people who are affected by the public charge rule that we're worried about are people who are trying to obtain permanent residence based on a relationship to a U.S. citizen. So under the immigration laws, both the marriage to a spouse as well as a relationship to other close blood relatives can lead to permanent residence. And when a person is seeking permanent residence through those channels in the US, it's called adjustment of status. So people who are applying for adjustment of status to LPR through family relationships, and some other people as well, are the most likely to be affected by any changes in the public charge rules, any expansion in the public charge rules. So some people apply for adjustment to permanent residence through other channels. So for example, a refugee or a person who was granted asylum in the US has an independent pathway to become a permanent resident after they've had that status for a year. That's called adjustment of status 2, but it's a different form of adjustment of status that doesn't have a public charge rule attached to it. So you saw in the video that there was a list of categories of immigrants who are exempt from the public charge rule. One big category is people who are trying to get adjustment of status through these special humanitarian laws that include asylum, refugee status, vehicles for battered spouses and children, special immigrant juvenile, which is an adjustment of status vehicle for children who are abandoned, neglected, or otherwise subjected to some findings by a state court judge that it's not in their interest to be returned to their country. And special other sorts of special laws that have been created for certain nationality groups over the years, including Haitians, Nicaraguans, Iraqis. There are some special laws that are created sometimes on a one-time basis, again, for some humanitarian reason that puts them outside of the normal adjustment of status admission rules and exempts them from these public charge criteria. So the other group of people who are not subject to the public charge criteria are people who are seeking statuses that aren't treated like an admission, which is kind of bizarre that we have these different rules about when immigration laws deem you to be admitted into a status and when the immigration laws are just granting you a status, but it's not deemed that kind of an admission. So for some of those statuses or some our examples are deferred action for childhood arrivals. The dreamer kids who have been here were brought here by their parents, undocumented. Under the Obama administration, they were provided with employment authorization and permission to remain if they qualified for DACA. So when they obtained DACA, they did not have to go through this public charge admission test. There are many other statuses that don't have the public charge test attached to them. They're exempt. Temporary protected status is another one, which is a form of, again, humanitarian status for people from countries where a catastrophe of some sort imperils their return. So right now we have that for Haiti, Honduras, Yemen, El Salvador. There are about 10 countries that are currently under a TPS designation. Of course, it's not guaranteed to end, and the administration has promised to terminate some of those TPS designations, but in order to get TPS, they do not have to prove that they are not likely to become a public charge. So those are sort of the primary, and refugees and asylees, a person seeking the humanitarian relief of refugee status or asylum status does not have to satisfy this public charge rule. Again, it's helpful to think about it as most of these exemptions are for statuses related to some humanitarian reason that the status even exists. So that's a way to help you remember them. However, even people who have one of these statuses, if they go back into the family immigration system later on and try to, what is 2.0 their status to a permanent resident instead of that other status they had, then at that point, the adjustment of status family rules would apply, right? And so there is a little bit of confusion and uncertainty in that population of people who are not subject to public charge, but might be marrying a U.S. citizen or hoping to, and then would have to go through the public charge test when they apply for adjustment of status. So let's see, turning to the next screen, the public charge test is not just about receiving benefits. So an immigrant seeking adjustment of status through a family member, for example, could go off every single benefit or never even receive a benefit and still be found likely to become a public charge or not. Because the public charge test is much bigger. You heard on the screen, it's not just about receiving benefits. It's about a prediction that the government makes in the totality of the circumstances. That's the test. That can't be changed, that totality of the circumstances test, because it's in the governing law for immigration authorities. So that test has a bunch of factors: how old the person is, how many family members they have. As you can see, they're on the screen. The good thing is that a person can try to use some of these factors to their advantage, right? To show, well, my family consists of mostly young, healthy, high-achieving children who are likely to get scholarships and never become dependent on the government, right? So that would be like a good situation. On the other hand, there might be people who have very serious situations that inhibit their ability to work, and they're low income, and they, even if they go off their benefits, whatever they are going to have a very hard time overcoming this, the public charge test anyway. So this is why it's been so complicated, I think, for all of you to answer questions from people, because there are so many factors that assessing or predicting the future for any individual, it can be very difficult. So let's see, what else can I say about the test? Yeah, okay, so we're going to move on to the next rule.
Okay, so now we're kind of getting into more of the intersection of public benefits and public charge, which I'm going to talk to you more about. So today, the public charge rule, which has been defined in this field guidance that's been out there for 20 odd years, there's actually no rule. There was a proposed rule in '99, it was never finalized. So we have this field guidance, and it's pretty narrow. It says public charge is primarily dependent on just two kinds of benefits: cash welfare for subsistence. So that's SSI, it's AFDC in Massachusetts. It's a program called Emergency Assistance, EADC, that's administered by our DTA, our welfare agency, or you're in a long-term institution at government expense. So that would be like nursing home care. Well, for the most part, It's hard to get cash assistance. The eligibility rules are really restrictive for immigrants. So other than EADC, there aren't a whole lot of people who aren't already legal permanent residents or exempt who are even candidates for getting cash assistance, much less having Medicaid pay for their nursing home care. So this hasn't been a huge problem. So that's made it possible for patient financial counselors and all of us who do outreach and work with people to say, don't worry about public charge. It's safe, except for cash welfare. That's more complicated. Then we have to get into everything that Iris spent 15 minutes telling us about, which is something it would be very challenging to explain to people, and most people don't get. They get, it's safe, it's not safe. And now it's pretty much safe because public charge is so narrow. And for those of us who work in the health space, it's absolutely safe. The 99 guidance says, this is public charge. No other benefits are. Non-cash benefits don't matter. All these, and then it kind of lays out examples. Medicaid doesn't matter. CHIP doesn't matter. Food stamps don't matter. Housing assistance don't matter. WIC doesn't matter. So it's made it a kind of clean message to convey to people, and a message we've been putting out there for 20 plus years, that it's safe, except for cash. Cash, you need a little more guidance and need to get into some of the arcana of who is subject to this rule and who's exempt and so on and so forth. So the leaked draft would really turn that on its head. Now it says likelihood of receiving any public benefit. Forget being primarily dependent. You're just receiving or using any public benefit. We're going to define public benefit very broadly. We're going to give you some examples of what we mean by that, but that's not exclusive. We mean everything that fits the definition unless it's specifically excluded. And we're going to give you a short list of what's specifically excluded: disaster relief, emergency Medicaid, public education. I mean, there's some stuff on that list, school lunches. But basically now it's open-ended. It meets the definition, and we know that they think that is going to include Medicaid, Mass Health. It's going to include premium tax credits, connector care, SNAP benefits, other nutrition benefits, WIC benefits, housing assistance, fuel assistance, even earned income tax credit. Those are kind of specifically spelled out in this leaked draft, but it's really anything that meets this very broad definition. It's not just federal government benefits, it's also state and local. So this really would be a sea change, and among other things, were it to become final, imagine your patient financial counselors trying to answer the question, well, is this safe for me? Are there going to be any problems with immigration? I mean, you need a 20-minute recital of kind of arcane immigration law to answer that question. So that will be one of the many challenges we'll be working on if this happens. Going to the next one, Iris was going to cover this, but I think we're running late. And since I know less about immigration law, I can do it a lot more succinctly. So there were more changes in this leaked draft. Basically, this totality of circumstances. What the totality of circumstances, what all these factors are enabling you to predict currently, even though you look at all these factors, what you're trying to predict is, are you going to be on cash welfare, or are you going to be in an institution at government expense? But under this new proposal, you'll just be predicting, will you ever use a public benefit that isn't one of those few that we've exempted? And they're saying if you've used a benefit in the last 3 years, that's a heavily weighted negative factor when we weigh up all these factors. The only good thing is that they're saying those benefits which we have not counted in the past, which is basically everything except cash and Medicaid if you're in a nursing home, if you get one of those, we're only going to count it against you if you are getting it after this rule takes effect. So that's why we feel it's safe and appropriate to tell people, don't worry about dropping your benefits now. There's no reason to do it now. And again, this is something that's in a leaked draft of a rule that nobody's seen yet. But hopefully it will be in the proposed rule. And if the final rule takes effect, it would be in the final rule too. So people will have time to weigh factors and say, it's more important for me to have the benefit, or am I one of these exempt people, or is it more important for me to get my green card and go off benefits? The other thing that's new currently, it is if your dependents are using benefits, unless it's cash and that's the only income for the family, it doesn't matter. The leak draft specifically says we're going to look at your ability to support your dependents, even if they're U.S. citizen children, and if they're using a benefit. That's a negative factor. The heavily weighted negative factors, some of those that Iris mentioned have nothing to do with your benefit use. If you just have a medical condition and you can't show that you have unsubsidized insurance or the cash to pay the costs, that's a negative factor, a heavily weighted negative factor. Currently, the way most family-based immigrants meet the public charge test, they're required to have an affidavit of support from a sponsor, and usually that's been enough. But now they're giving less weight to that affidavit of support. You still have to have it, but just having it may not be enough to satisfy immigration officials. Instead, what they've said is if your income is over 250% of poverty, and the affidavit of support level is half that, so that's a lot higher income, then that's a heavily weighted positive factor, or if you put up a bond. So basically, this is a theme. We've heard this from the administration. Family migration is bad. It's chain migration. We want people with money. We don't want regular families coming over. And finally, the last point is a little more arcane, but there are some people who are not strictly speaking subject to charge. They have a non-immigrant visa, like temporary workers, exchange visitors, students. They want to extend that status or change to another non-immigrant status. It's a discretionary decision by the immigration officials, and the leaked rule also says they're going to take account of benefit use there. So that would also be an impediment to that category of people, even though technically it's not public charge. So if you go to the next slide, this is kind of what's happened so far, why we're here talking about this now. So last year, the Department of Homeland Security, they publish in kind of an official way what their plans are for the rules and regulations they are going to propose in the coming year. And they've said in that kind of official way, we're going to change the public charge rule, and we anticipate this is going to be July 2018. So that's a solid, real thing, not a leak in the press. That happened. Then in January, there actually were some changes in a foreign affairs manual that is used for consular processing abroad. So when you see all the statements saying, it's safe, nothing has changed, usually they say, in the US. Nothing has changed about how public charge works in the US, because something has changed for consular processing abroad. They haven't really changed the definition. They've changed the weight given to the affidavit of support. They've changed the benefits they look at in the totality of circumstances. We're running a little late, but if you have more questions about that, Iris can definitely tell us a lot more. I'm just going to kind of whiz through this. The next thing that happened was our first leak of what this rule might look like. This was in Vox. This was kind of short. It was pretty scary. Then in March, there was a much longer leak. This is like 200 pages that the Washington Post got its hands on. Most of it preamble explaining what and why what they were doing and why. And then that's the text of the rule when we talk about the leaked proposed draft. This is where it came from. Then the other kind of official thing that we know happened is that the Department of Homeland Security did submit a rule to the Office of Management and Budget, OIRA, Office of Information and Regulatory Affairs, which is a step towards publishing the proposed rule. So that happened at the end of March. That's where the rule is now. It has not yet been proposed. At some point, it will be proposed. It will be published in the Federal Register. And if you go to the next slide, this is sort of what happens next. Once it's proposed, it's not the rule, and they have to have a comment period. The leak says 60 days, could be less, but probably a 60-day comment period. When the comments are submitted, the agency reviews them and makes a decision on the final rule, which is published. The final rule doesn't take effect right away. Again, there'll be a delay before the effective date. Right now, we think that will be 60 days, but that we also don't know for sure. So this whole thing is probably, even if something were to come out tomorrow, it probably would be 6 months away from actually taking effect. And then there are very possibly legal challenges. We've seen that to a whole host of proposals. Kind of depends on what the specific rule is. So part of what we're doing here today is we want to educate people about what's happening, prepare people to talk to your patients and clients and people in the community about it when the proposed rule is out, and also encourage people to file comments. And I know Kate is going to talk about that more, so we're kind of skipping the action step. I just want to move quickly into the kind of the nature of the harm here. Okay.
Vicki will talk to you more about the chilling effects, but I just wanted to talk about the immigration consequences if this were to actually be effectuated, a final rule were adopted, and then immigration started to implement it and no court stopped it from happening. So more non-citizens will be denied admission both at the port of entry as well as when they're adjusting to permanent residents based on a ground that the public charge rule applies to. And consequently, what happens when people are denied adjustment of status, if they have another status, like they're a student or they're, in something else that still is still ongoing, they would return to the status that they had, which may be inferior. But the big problem is for people who have no other status to retreat to, because then quite possibly they would be issued a notice to appear for removal proceedings and be put in essentially a deportation case, not because of the public charge, but because they don't have a status, and so they are deportable for having no status. So that's a pretty scary consequence to befall people. As far as actual removal on public charge grounds, there is a part of the rule that we didn't spend much time on, but that was left blank in the leak version that says that the federal government would also be changing or intends to change the public charge deportation rule. So the public charge deportation rule is very different from the public charge admission rule. It's hardly ever used because under the current interpretations of that rule, a person can only be deported if they are essentially required by the benefits law to repay the benefit, and the agency that gave them the benefit asks for the money back and the person refuses to pay. It's a very unusual test and hasn't been used for decades and decades in very many cases. So if that were to change, then people could also face deportation on public charge deportation grounds. But right now we're not really focusing on that because also we question whether the government would be permitted by a court to implement that part of the rule because it's based on long-standing court decisions. And then the other consequence, just briefly for immigration, is Vicki mentioned the non-immigrant. So when a student tries to get a permanent, another non-immigrant visa based on employment, for example, many times students acquire education and then become work in a more secure occupation. They would be denied their change of status to that other status. So that would affect thousands of people in Massachusetts.
So Iris just talked to you about the direct immigration consequences, but a lot more people would be affected by what we're calling the chilling effect. And this is people afraid to apply for benefits. The public benefit rules themselves, the eligibility rules, aren't changing. Since the late 90s, they've been very restrictive for immigrants. It's been much harder for immigrants than for U.S. citizens to qualify for public benefits because of changes made in the 90s. Despite that, this rule is attaching negative immigration consequences to people using the benefits that they do qualify for. The rules for the benefit programs aren't changing. And the consequence that we know we're going to see, in part because we're hearing it already, but in part because of actual data from the 90s. When they made the immigration rules more restrictive, they looked at how did that affect people who actually were still qualified, the U.S. citizen kids, the refugees, and they found their participation in public benefits plummeted too. So we know we're going to see this not just among the people who have an application for adjustment pending, but among a much larger category of people. And the harm of people not taking advantage of public benefits they need and qualify for is kind of obvious. They're going to go without nutrition benefits, healthcare benefits, housing programs, even programs that increase their skills and make it less likely that they'll ever need public assistance, like subsidized job training and programs like that. That also will harm institutions that primarily serve or disproportionately serve immigrants. We're really worried about community health centers, for example, for whom part of their mission is really serving the immigrant population, and people may be coming to them for care but may be afraid to apply for the public benefits that would pay the health centers for the care they provide. Hospitals will see this too. Emergency Medicaid is actually not covered, but this could affect hospitals as well. And we know from all the work that's been done on the benefit of expanding coverage, especially here in Massachusetts, the reverse of that, the harm of people being specifically uninsured, but the same goes for people without enough to eat or without adequate housing or without any of the benefits that are available and that the population at large widely participates in. I mean, in Massachusetts, we have, if you look at Connector Care and Mass Health, we have over 2 million people of our 6.8 million population who are benefiting from those programs. That's not like a odd little outlier program, and it's not true that immigrants disproportionately use benefits. They're using the benefits that everybody uses to support families in the modern world. So looking at more specifically at who's affected, I sort of think of this as the pebble in the pond and the waves radiating outwards. So we start with the non-citizen who actually has a pending family-based adjustment application who may have public charge test applied to them and may be denied if they've used a public benefit or may be likely to use a public benefit. Then we have the family members. This is family-based immigration. So this non-citizen is going to have a family member, maybe the U.S. citizen kids or the U.S. citizen spouse or the legal permanent resident family members. Then we sort of move out from there to people who aren't now in the pipeline for a green card, but reasonably expect they will be. We move out further from there for people who aren't in the pipeline to get a green card, maybe have no path there. Maybe they're DACA and their family's undocumented and they don't have any U.S. citizen or legal permanent resident family members, and maybe they're not candidates to have the kind of education and training that would enable them to get an employment-based immigrant, but still hope that someday they will have a path to get a green card and their extended family members. Then we have, again, the U.S. citizens and legal permanent residents who are fine themselves, but would hope to sponsor a family member. And some of these changes, especially giving less weight to the affidavit of support, suggests that their use of benefits may make they'll still be able to submit an affidavit of support, but it may be less persuasive that the family member they want to sponsor will not become a public charge. So they may be afraid of their own use of benefits. Then we get into all the students, the exchange visitors. And then again, what we know from the research I mentioned earlier it's not going to be limited to even those people, even folks who are exempt, the refugees and the others who have nothing to fear from a public charge test, as well as legal permanent residents who want to be U.S. citizens. Public charge doesn't apply to that move from legal permanent resident. But again, the misinformation is going to be out there, and we're already in a culture of fear because of ICE enforcement and all kinds of things going on. So potentially really anybody with any tie to a non-citizen in Massachusetts could potentially experience this chilling effect and be afraid to apply for benefits. So
I think that's a great place that we can just maybe pause for a minute. I know we've covered a lot of material. So I want to let folks in the audience and online know now is a great time to start getting your questions together. And Reagan will be walking around with a blue basket for you to place those questions in. Even if you have to leave a little bit early, make sure that you get your questions to Reagan. We can answer those in our newsletter. So I am just going to move quickly, and please make sure you also signed in for today's program because we will email you the slide deck. And as we will have to skip through a few of the slides. So we will move to your questions in about the next 2 minutes, but I just want to cover a few things from the perspective of Boston Children's Hospital. So hopefully many of you have seen in your inbox correspondences directly from hospital leadership, looking at a range of the different immigrant issues that are currently unfolding in the landscape. That is why we are doing this program today. That is why the Office of Government Relations is deeply committed to partnering with folks like MLRI to address these issues as they arise. So what are we going to be doing specifically around the public charge? Well, there is a national campaign called the Protecting Immigrant Families Campaign, which was mentioned in the video as being spearheaded by NILC and also by CLASP. And Amy DeLong from the Office of Government Relations that handles our federal affairs is working directly with the National Protecting Immigrant Families Campaign on this public charge issue. There is also a local chapter of Protecting Immigrant Families. That's the PIF Massachusetts chapter, which I am partnering with along with MLRI and many other coalition partners in the community that we work with. So we are deeply connected in monitoring this, both from the federal and the state level. So what are we doing? We're preparing to comment. You heard a little bit of background about where we are today and what we think might be happening. So I look around the room and I see lots of familiar faces of people who have already contacted me about this. And we have a matrix of interested patients, family, staff, providers here at Children's who want to comment on this if and when the time comes. If you are somebody that is interested, please contact me, Kate Audette, with your interest, and we can get you in the queue and start to do a little bit of prep work now so that if and when this rule is released, I have a strong bench of individuals who are committed to providing comments on the public charge. Because the national goal of the Protecting Immigrant Families campaign is going to get 100,000 unique academic cited comments to the rule, because the more comments that we get to the rule, the longer it will take the federal government to review them, and this will essentially help slow down this process and allow us to put in step the next phase of the advocacy strategy. So I cannot think of a better place to write well-cited academic responses to the public charge rule than Boston Children's. So we want to do our part in the larger campaign by ensuring that we are getting these comments. Sometimes in the work of advocacy, you all hear from me and we're doing things like sign-on letters or petitions. This is unique. We're not looking at lots of you signing on to something that one person wrote. We're not necessarily looking for petitions. We need these unique, lengthy, if you can write it in multiple different languages, that is also a benefit, comments that we can then submit. All you need to know is that you have an interest in this issue and you think you have a unique perspective. The Office of Government Relations will take it from there and provide you with technical assistance and all the tools you need to comment. So again, just be in touch with me if this is something that you or your colleagues think you might be interested in. So here is my contact, as well as the contact information for both Iris and Vicky, along with some of the other amazing advocates that are on the front line of doing this work. Again, don't worry about scribbling it down. You will get the slides. For internal resources, I want to let you know that we have an Office of Immigrant Services here at Boston Children's. So if you are encountering specific patient family questions, employment questions that pertain to immigration, the phone number is here. You also see a screenshot from the intranet where you can get more information. Also on this page, we have a medical legal partnership, and I see our friends from the medical legal partnership here. If you want to wave your hands, Shanika Davis is here, who can also provide support to patients and families that have questions, not just about immigration, but housing, a range of different legal issues. So there are lots of resources internally that you can provide folks with now. If you want to watch the video again or share that video, the link, the information for that is here, along with additional information about the PIF campaign. And now we are finally ready for questions. So Reagan is going to bring them up. We have about 10 minutes for questions. And again, anything that we don't get to, and I'll give that back to collect some more, anything that we don't get to, we will find ways to distribute this information through the CAN. Let's see. So let's start with this one. What would happen in the case of a family who originally came here short term, but ended up being here long term and in need of public assistance?
If they were eligible for public assistance, and they received it right now, if it were cash assistance and they were adjusting status through a U.S. citizen family member or permanent resident family member, they would have to overcome the public charge rule through an affidavit of support, or more than one affidavit of support. Under the proposed rule, the fact that they received the benefit would be it would still be considered a negative factor. The affidavit of support wouldn't be sufficient, and they would have to come up with other factors and other proof sufficient to meet the new test.
That is maybe about an undocumented family. And, you know, people qualify for benefits now, and there are health safety net benefits available for the undocumented. The eligibility rules aren't changing. Whether public charge is a factor they should take into account in deciding whether to use public benefits that they may qualify for kind of depends on whether they have any realistic prospect of ever being in the position of applying for adjustment or getting a green card. Unfortunately, for a lot of undocumented people, there just isn't a path for that, in which case this really is not particularly relevant to them.
So thank you. Keep all these great questions coming. We have a lot of really great questions, and what I'm going to do is consolidate areas where we have a clear theme, and we'll try to address those. So I think this one is important. We have an internal question about ICE and other officials coming onto BCH property and asking information about our patient families, staff, or other legal matters. Should that happen with any type of law enforcement official or anyone here on the BCH campus, you should immediately contact security here at Boston Children's Hospital and then contact the general counsel's office. So you should not feel that you have to go this alone. You have support from both security and the general counsel's office. I might add, you should probably also alert your immediate supervisor to what is happening. So in the event that that happens, please contact security, the general counsel's office, and alert your supervisor. Those internal intranet web pages that I mentioned has more detail on that if you have more specific questions. Another one I think I can answer quickly. What is the timeline for the prospective public charge rule change? We don't really know a timeline, but I can tell you in the Office of Government Relations, as I'm sure MLRI and many of you are, we're watching and checking daily. And if you have contacted me and said, Kate, I'm interested in submitting a comment, at this point, you're probably getting a weekly email or sometimes every other week from me saying nothing has happened yet. But we can guarantee you that the second anything happens, we have a well-coordinated network of advocates that will be alerting those interested as to what is going on. really important question, and I think very appropriate here at Boston Children's. We have several questions about how these proposed changes may possibly impact children with medical complexity, SSDI, SSI benefits, and just children with medical complexity in general.
The benefit eligibility rules don't change. Among the exempted benefits in the leaked rule are earned benefits. So Social Security disability insurance benefits, which are earned benefits for a child, it would typically be because of the parents' work history. That would not be considered for public charge purposes. SSI is considered now. It's a cash welfare program, but not if but only if it were the sole source of support for the family. I actually don't know offhand what the SSI immigrant eligibility rules are for children. Generally, the SSI rules are among the most restrictive, but maybe that's not true for children. I don't know. For Medicaid and CHIP, again, the children would remain eligible. It's just this rule would say if you have a family member who is going to be seeking adjustment of status, we will look at whether that family member is likely to become a public charge, and that includes looking at whether they have a dependent who is using a public benefit, and that will be a negative factor, but there's a weighing of factors. So there may be a lot of compensating positive factors so that that would not be an impediment. And again, it only applies to people who are kind of in the pipeline for having this public charge test applied to them, which is something you invite. I mean, you are saying, I want immigration relief. Please give it to me. And they will say, prove to us you're not going to be a public charge. The removal is a different story, and we just don't know what that's going to look like yet.
There are some other children that over the years I've had interactions with folks at Children's about. One of them are people who have come here, a kid has come here for treatment, and they're given humanitarian parole status. That status isn't subject to public charge, so that wouldn't change. But the others are those who come here on a temporary non-immigrant visa. Remember I said that there are those visa prohibitions on receiving benefits. So if the person is trying to extend a visa for medical treatment, a non-immigrant visa, then the receipt of benefits by the child would be, it would bar that extension. So that would be a very harmful impact for that population too.
All right, so we have time for one more question, but I'm going to multitask a little and start with a quick reminder for those online to use the link for the evaluation, and those in the room, please complete your evaluation forms that you were handed when you arrived. We got a question about what to say for patients and families. So that was one of the slides that we kind of skipped over, but it was also included in the video. So I'm going to put that up, but I'm also going, because I'm multitasking, to give you your final question. And that is, how does a person pass this test? Is it related to income, home ownership, education, a degree? How does one pass the public charge test?
Right now, people traditionally do it by submitting one or more affidavits of support. An affidavit of support is the sponsor's guarantee that they're going to help you financially stay above poverty. Sometimes the family themselves are not adequately resourced to be able to provide for one another, so they'll get an affidavit of support from someone else. I assume that in the future, people will continue to try to use affidavits of support, and that even after this changes, there may be a need to do more affidavits of support. But sometimes people who are not related, when they file affidavits of support, they're not looked upon with the same degree of credibility, because immigration authorities will wonder, why is this U.S. citizen neighbor willing to support this person? So So that will be difficult. But the other way is by essentially trying to document all the ways with an advocate, with an attorney, all the ways that that person's skill set or capabilities, job offers, etc., are collectively enough to show that in the future, remember it's a future test, they are not going to be dependent. Now, as I said, it's very affidavit of support driven, but I under this test, that won't be enough. And so these public charge bonds of $10,000 are going to be another feature, I think, of immigration practice where people have to come up with $10,000 in the way immigrants in the detention system today have to post bonds. They end up going to these companies that lend them the money and then jack up the repayment interest rates to extraordinary levels. So it's a very borderline usurious practice that I'm fearful would also be prevalent.
Thank you, Iris. Well, so on that note, we're out of time, but I want to end on a positive note and say just how proud I am to work at an institution and be surrounded by colleagues and community partners like all of you that take time out of your day to discuss these critical issues that are facing not just our patients and families, but really our communities, and how thankful we are that for the last 50 years, we have had MLRI as a partner in this work. And thank you for your continued support moving forward. Thank you to all of us for joining us today. Thank you to everyone live streaming. Can we have a round of applause for MLRI? Thank you so much. Enjoy the rest of your day, and we look forward to seeing you at future programs brought to you by the Office of Government Relations. Thanks, everybody.